Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV130520, Jackson versus Jackson. Counsel, we are recording today's proceedings, so when you step to the podium, if you would, please identify yourself and the party you represent. Each side will have a total of 20 minutes for argument, and counsel are responsible for watching the clock on the podium and reserving any time for rebuttal that you might desire. Technically, since we have a cross appeal, Mr. Gardner would have the last word as to the cross appeal if there's time remaining, but the bottom line is you've got 20 minutes to use as you wish. We have read the briefs and we've conferenced the case prior to argument. So with those preliminaries out of the way, Ms. Ansel, you may proceed.
May it please the court, my name is Yvette Ansel and I represent the appellant and the cross appellee, Philip Jackson. And Your Honor, just a question of procedure in terms of responding to the opposite motion. Would you like me to do that now in my argument or in my rebuttal after he's had a chance to present his argument?
The technically correct way would be after he presents his argument, but if you want to throw in some argument on it, I don't think it would be a
Thank you, Your
problem.
Honor. This matter involves an abuse of discretion by the trial court in allowing a mother to relocate minor children to Sweden. The trial court abused its discretion by granting relocation and a complete alteration of the parenting time only 7 months after the decree was executed. The trial court abused its discretion by failing to state appropriate reasons for granting the relocation and granting mother sole legal decision-making under the statutes. The trial court abused its discretion by allowing the children's relocation to Sweden despite the majority of evidence supporting the contrary and despite the best interests of the children, which would favor allowing the children to remain in Arizona. The trial court abused its discretion by allowing the children to relocate to Sweden, despite evidence that the relocation would virtually annihilate father's relationship with the children. The trial court abused its discretion by allowing the children to relocate to Sweden after mother testified that she would move back to Arizona with them if the relocation was denied, meaning that the children would be able to have a relationship with both parents in Arizona. In this case, the decree was entered in...
Let me ask you about that last concession by mother, and that is in the record, but doesn't that suggest, is your argument that anytime a parent who is intending to relocate says, look, if my motion's not granted, I'll stay here, that the trial court must deny the request for relocation?
No, Your Honor, but in this particular instance, given all the other factors that would weigh against relocation and mother's reason for relocating in this case, because the mother was willing to move back, that relocation should have been denied.
So is that the dispositive issue that she indicated she'd be willing if the motion was denied to stay?
Well, Your Honor, that's one of the another factor that would weigh in favor of having the children remain in Arizona. But no, that is not the only.
But let me ask, and I understand, abuse of discretion is a pretty forgiving standard from an appellate review, and I understand the arguments that you're making, but how are those effectively errors of law as opposed to arguments that the trial court could have evaluated in a different, come to a different conclusion?
Well, in this case, Your Honor, in terms of the discretion of the trial court, it's not just about listing the factors and plugging in what the evidence is, and then not paying attention to the fact that all the evidence weighed in favor of the children remaining in Arizona. In this case, that's just what the court did, plugged in all the factors and ignored the fact that the majority of the evidence should favor denying the relocation in this case.
I understand that, and you've said that before. I wrote it down, the majority of the evidence, but that suggests the minority of the evidence cuts the other way.
Well, the only minority of the evidence, that was questionable too, Your Honor, because initially when a certified letter went to father, the certified letter said the reason for the relocation was for better opportunity for schooling of the children. Then all of a sudden we went to trial, and it was because mother found a job in Sweden when there was sufficient evidence, and mother testified that she had other opportunities for employment in Arizona. Those were the only factors that weighed in favor of relocation. So it wasn't a determination on the best interests of the children, because it wasn't for better schooling opportunities as originally stated, but rather it was only for a job that mother had found in Sweden, whereas she could have found jobs in Arizona.
Well, and in fact, if I remember right, she had other employment opportunities in Arizona, but she perceived them as not as favorable as the ones that she had in another country.
Correct. There was one opportunity, although as soon as she got the job offer and executed that employment contract in July, she stopped looking for any kind of job opportunities in the United States.
Is that typically how it works? When you accept a job, you quit searching for a different job?
Except, Your Honor, that there was a paragraph in the parenting plan that was made into an order by the court in the decree that she wasn't allowed to relocate unless there was a court order or unless there was agreement of the parties. Clearly, father had already told her, no, I don't agree, and she didn't bother to seek a court order.
Well, isn't that why we're here, though? The court order was sought.
Well, but after, Your Honor, and she was actually found in contempt because she didn't seek that court order.
Yet still the Superior Court granted her request.
Correct, Your Honor. And the argument father has is that it improperly granted the request because there wasn't sufficient evidence to meet her burden that a relocation to Sweden, to another country, where it would in fact annihilate the relationship between father and the children, that was sufficient to grant her relocation.
And what I'm struggling with a little bit with your argument, and then I promise you I'll be quiet now to let you continue forward, is the arguments you're making in the first instance to the trial court, great discretion is afforded that trial court, and our review is comparatively limited on an abuse of discretion standard, as you quickly concede is the standard for review here. And what I'm struggling with conceptually is how the argument that you're making isn't effectively asking us to reweigh the same evidence and come to a different conclusion. So if you could address that, I would very much appreciate it.
And I'm not asking the court to retry because I realize that that's not what the standard is here. However, anybody just objectively looking at what the evidence suggested would, and Dr. Weinstock, who was the custody evaluator, made several statements in the trial saying...
Interrupt you. He wasn't a custody evaluator. He had a very limited role, which was just to advise the court as to whether the children would suffer some detriment by staying in Sweden. Isn't that correct?
And that is true, Your Honor, and we did actually request the court to expand his role into a full custody evaluation, and that was denied. So father's position at that instance was that his role as that limited focused evaluation, only focusing on one little aspect, was insufficient to give the court enough basis to decide one way or the other. However, Dr. Weinstock did testify as to some of the other factors.
He did, but he wasn't ordered to do that, and the ultimate issue he was asked to opine on was actually in favor of mother's relocation, wasn't it? He said that it was unlikely to have a significant effect on the children's stability.
On the children's stability, correct, Your Honor, but he did specifically state that...
I understand he offered other opinions, but the court only asked him for input on that one issue. Isn't that true?
That's true, Your Honor, but the standard is, under Hayes v. Gamma, that the court has to accept and hear all evidence regarding the best interests of the children. And Dr. Weinstock testifying about the other factors has an impact on the best interests of the children. He actually testified that it would significantly, detrimentally affect the relationship between the children and father if the children were allowed to move to Sweden. It would be a negative, weighing against the relocation. In fact...
You probably don't need an expert to say that, of course. But I'm coming back to Judge Thumma's point. I'm puzzled by your position that the court's findings were inadequate because, frankly, in 17 years on the bench, I've rarely seen such detailed findings in 21 pages. And when I read your opening brief before reading the minute entry, I thought I was going to find the court saying, father said this, mother said this, father said this, mother said this, and that's not at all what the court does. The court makes actual findings based on the evidence. I guess I'm very puzzled by the contention that these findings, you can disagree with the findings, but their inadequacy, I'm not seeing that at all.
Well, if you read the findings, it's a listing of the findings, but for instance, if you look at the findings and then the factors, they don't match granting the relocation. For instance, one of the factors has to do with which parent is more likely to allow meaningful contact with the other parent. Well, the court lists the factors. However, it's not mother who would allow that, and mother's the one who's moving the children all the way over to Sweden. It's father. So, in fact, that factor would weigh against the relocation because if you have the parent who's moving the children across the country or across to another country, and she's not the one who's allowing meaningful contact, then you've got an annihilation of that relationship between father and the children, and that has to be taken into account by the Superior Court, which they didn't take into account. Another factor...
Well, how do we know that the trial court didn't take that into account?
Well, because it would be a factor that wouldn't weigh in favor of the relocation.
Your position, but by definition, it's a factors test. It's not an elements test.
There wasn't enough in the and I understand that it was a 21-page decision, but the problem was there wasn't enough in the decision to say, well, this factor weighs in favor of mother and her relocation. There was a listing of all of the evidence under the factors, but when you read the listing, all of the listings would favor father and having the children stay. There was never a statement by the court saying either why there was a discount of, for instance, Alyssa Liner's testimony, who said that mother 6 months before the divorce said, I'm going to move to Sweden and father's too lazy to do anything about it. And that's one of the factors that the court has to consider, what the basis, if there's a good faith basis for a relocation. Well, that testimony went undisputed by mother, yet the court didn't explain why that factor wouldn't weigh in favor of the children staying in.
So your position is, if I'm hearing it right, that the trial court not only needs to evaluate the factors, the evidence offered in support of each factor, but to the extent any testimony is discounted, that the trial court needs to expressly state that and state why.
Absolutely, Your Honor, because otherwise, if you just read that decision and you come to the objective conclusion that all of these factors weigh in favor of father, and some of them literally state this weighs in favor of father, why would the court then come to the opposite conclusion without any explanation whatsoever?
What's the best case supporting your position in that respect?
Well, all of the cases listed where the court has to specify under 403 what the factors are and the basis for the reasons of the court's decision with those factors.
Which one of those is
And Your Honor, it's all the ones that I listed in my opening brief. It would be, I believe, Reed, Owen versus Blackhawk.
And counsel, if the answer is all the ones in your opening brief.
Okay, thank you, Your Honor. In terms of all of the factors, I won't reiterate because they're pretty much set out in my brief, and I don't want to be repetitive. However, Your Honors, even the actions of mother in not bringing the children back to the United States over and over again would weigh in favor of denying this relocation. We've got mother initially with scheduled flights to come back in August of 2012, and she just decided not to. We've got a request by father to bring the children back over the winter break. He had not seen the children for 6 months at that time, and she stated to the trial court during a telephonic hearing that she didn't want to do that because she'd already told the children that they were going to travel around Europe and they were excited for that. And then when the court said you should consider bringing the children back, the mother only brought one of the children back. She also, when the court issued its final order and said that father gets the children a week after the court's decision, and I believe the court's decision came out on June 24th, mother had scheduled tickets to bring the children back on June 30th, yet she chose to wait another week and not bring the children back until July 7th. So she's not following court orders, and she's the one who's in Sweden with these children. The fact that father cannot have consistent parenting time with these children, the fact that the only reason that these children are being relocated is because mother has some kind of employment opportunity in Sweden, yet she herself testified that she's got these opportunities in the United States, but she didn't bother to further look for them. Your Honors, I'm going to reserve the rest of the time for my rebuttal. Thank you.
Thank you. Mr. Gardner.
Your Honors, good morning. Attorney Douglas Gardner. I represent the appellee and petitioner Annika Jackson. The parties reached a stipulated parenting plan which had mother as having sole custody back when we had custody, the equivalent of legal decision making now. And in that parenting plan, it specifically stated that it was anticipated and considered that mother at some point may want to relocate back to Sweden. This was not something that was simply thought of at the last minute. This is something the parties had discussed for some time. The court then, after the trial, as has been pointed out, entered a very extensive 21-page ruling on the findings and factors and found favorable to mother. And while father didn't like the result then and still doesn't like the result, that doesn't cause any abuse of discretion. The trial court properly considered the evidence, and many of the factors, most of the factors, favored mother's relocation, and the court therefore granted the relocation. It appears that the main reason why we're here today is, as was stated in the trial court, mother testified that father had threatened to destroy her financially if she insisted on going forward with the relocation. He did that at the trial level, making that a very expensive trial, and he's continuing to do that now, bringing this appeal based on an abuse of discretion when it's quite clear, based on a 21-page ruling, very detailed ruling, that there is no abuse of discretion. I'd like to focus primarily on an issue that actually deserves consideration on an appeal, and that is the abuse of discretion of the court's allocation of the travel expenses, and then the de novo review of the court's inappropriate deviation of the child support issue. It's important to note that father earns about $12,000 a month, and mother earns only about $7,000 a month. Now, also brought up at the trial level, because mother is in Sweden, she pays a much higher tax rate than father does, and our child support guidelines take into effect how much each parent actually pays themselves out of pocket for medical expenses or medical insurance for the children and daycare costs for the children. Now, mother in Sweden doesn't pay as much out of pocket, but pays 50% taxes, and therefore gets reduced medical and reduced daycare expenses. So our child support guidelines don't fully take that into account, just because our guidelines are based on two people here in the United States in the same tax brackets. So really the income discrepancy between the parties is much higher, or the child support would be different simply because mother's not getting credit for what she's paying in taxes for the child support and the daycare costs. Now, additionally, the first thing the court did, and this is admittedly abuse of discretion, but the first thing the court did is, in allocating the cost of transportation between the parties, the court should have done that proportionate to their incomes. But instead, the court started out saying we're going to make this equal. But the problem is, because of the children's ages, they're both under 9 years old and will be for some time. Anytime the children travel, they're going to be required to have an adult travel with them.
Let me interrupt you, Mr. Gardner.
Please.
Because Section 18 of the Child Support Guidelines says that the court may allocate travel expenses of the child associated with parenting time in cases where one-way travel exceeds 100 miles. In doing so, the court shall consider the means of the parents, which you've discussed, and may consider how their conduct, such as a change of residence, has affected the cost of parenting time. As you said, and as we gave Ms. Ansel a hard time about abuse of discretion, I'm having a difficult time seeing how this court can say no reasonable judge could have issued this travel allocation order. I think you have something to talk about when it comes to child support, because my reading of that same paragraph implies that travel expenses should be dealt with in a travel allocation order, not in a deviation from child support. But I'm having a hard time seeing how this was such an outlier decision in allocating the expenses that we would step in and set it aside.
Good. I think you're reading my mind. What I want to show is the unfairness. I want to show that there is a place to deal with it, and I like the way you argued. Maybe I should have hired you to write my brief for me. There is a place here. You know, the traditional way is you divide it equally between the parties. The court then went beyond that and said, I'm sorry, proportionate to income. The court went beyond that and did it equally on its face, but the reality is mother ends up paying 2/3 of the cost because she has to pay 100% of her or some other adult to travel back and forth with the children, and then father would only pay half of the children's cost. So father's only paying 1/3 of the travel for the children. Now, there was no evidence at trial as to the cost of these trips back and forth. There was one ticket that father showed, and this was at a time that mother said there was no tickets available for her to exchange. She had a ticket with a specific airline. She said there was no tickets on such a short notice to change to a different date. Father went online and found this $2,000 ticket at the last minute, which is going to by nature be much more expensive. And so there's a $2,000 ticket on a different airline at the last minute. But other than that, there was no evidence as to the cost of travel back and forth from Sweden to the United States, but presumably much less than $2,000. And if the children, and when the court then, moving on to the de novo issue of the court waiving child support, deviating from child support, the trial court basically waived $16,188 per year in child support and said, Father, don't worry about paying that because what you're going to pay in travel costs will eat that up. Now, even if the two children, he's only paying half of that. If the two children had $32,000 a year in travel costs for the two children, meaning the two children traveled back and forth 16 times, which they don't, then this number, the $16,000 waived in child support, would only at that point would it equal the cost of travel with this absurdly high $2,000 per trip, which is not what the cost would be, much lower than that if they were able to purchase the tickets in advance and schedule that. And so the trial court, it's an error of law because the court failed to make any specific findings supporting that, as is required by the law, and there is no finding that mother failing to receive $16,000 of child support in any way is in the children's best interest. The court failed to find any way to show that this $16,000 a year in child support was inappropriate or unjust. And so, again, this is the primary point that we want turned over on appeal and sent back to the trial court, is to have implemented at the trial level the father's responsibility to pay child support pursuant to the guidelines.
I'm sorry, counsel. So you agree that the court should have dealt with it with the travel allocation?
I think it was an abuse of the discretion of the court to do that. Again, that might be my myopic point of view.
Abuse of discretion for the court to do what?
Are you talking about the allocation of travel or the child support? Maybe I misunderstood your question.
It ended a zero support order to offset travel costs rather than leaving child support alone and as a separate issue issuing a travel allocation order. That's what you think the court should have done?
Well, I think the court...
We liked Judge Downey's briefing of it, so that's why I'm asking you that.
She was very blunt, and I appreciated that. I do think the trial court abuses discretion in its allocation of travel costs. I think it unfairly penalized mother. I think the issue, if the court, as it did, found that the relocation was appropriate, I think the court should not penalize to too much extent mother for the relocation that the court found is appropriate. Now, the law does give the court some leeway in the parent that is whose decision is causing the cost to do that. But I think even then the court went a few too many steps. Separate from that, I think the child support is sacred and should be for the children and should be left. And so I think the court, not just an abuse of discretion, but an error of law when the court then waived $16,000 and change per year of child support that is intended to benefit the children, that the children will not receive any benefit for, and certainly vastly exceeds any amount that father would be called upon to pay in transportation. And so basically father is getting a windfall of $12,000 or so per year, the way this court, the trial court, ruled on those two issues.
Not certain of that, though. If the court had left child support alone and just issued a travel allocation order and made mother pay 100%, you've got two little kids and then an escort that has to go with them, that's 3 tickets. I'm just saying, that it might well have exceeded $16,000 for 3 tickets to go back and forth to Sweden?
Very likely would not have, and more importantly, the court did not hear the evidence, nor consider the evidence, nor make the written findings of the evidence, 3 very important steps necessary before deviating. And so in speculation, we can discuss that today, but the lack of any evidence at trial on the issue, the lack of the court making written findings as is required for a deviation, it's one of the few areas where written findings are necessary, and entering those findings here as to how those are in the best interest of the children, that's what's completely lacking here at the trial level for the deviation of child support. Your Honors, I would like to reserve the time, even though we're the appellee, but because I think this is the primary issue, and I want to reserve time for rebuttal.
Thank you. Ms. Ansel, rebuttal?
And Your Honors, I'm going to briefly talk about this allocation issue. Abuse of discretion is the standard, and in this case, Mr. Gardner said that there was evidence presented that this was some kind of unusual ticket. That there wasn't. Father presented evidence that the cost of a ticket from Sweden to the United States was about $2,007. There was no evidence on the other side. That was unrefuted. It could have been presented. It wasn't. The court also allowed father, in granting the relocation, monthly visits to Sweden. Obviously, even if the children weren't coming this way, if he was going that way, not only would there be a cost of ticket, but there would be other living costs involved. So the court was well within its discretion to deviate the child support and allocate the travel expenses in this manner, because it probably worked out to mother's benefit and the children's benefit to do this. And in terms of father getting a windfall, there is no windfall for father here. His children live in Sweden. The children's first language is no longer English. There is no windfall for father in this case.
Counsel, let me ask you, your position then for the child support obligation reallocation is that the trial court made appropriate and necessary findings for that?
Correct, Your Honor. And father is more than happy to urge this court to reverse the decision regarding relocation, and he is more than happy to pay his child support obligations pursuant to the guidelines at that point.
Following up on Judge Thomas' question, though, I couldn't find where in this 21-page ruling the court made findings about the children's best interests as to the elimination of child support. Is there something I'm missing?
Well, I believe, Your Honor, the court determined that based on the fact that they granted the relocation, based on the fact that there was the cost of the tickets, she didn't specifically say it's in the best interests of the children. However, the way it allocated out, it would be in the best interests of the children, given that the costs to mother, which would affect the children, if he awarded the child support and then left all the travel expenses to mother, would work to the children's detriment.
The problem with that is the court is specifically required to make a written finding that a deviation is in the children's best interest, and that's what I'm struggling with.
And, Your Honor, maybe the answer to that is to just remand back to the court to make that specific finding to support what her decision was. In terms of the other issue on the relocation, Your Honors, all of the factors or all of the evidence listed in the 21-page ruling, the court did not make specific findings regarding whether the factors that supported father and against the relocation, why her decision to actually grant the relocation was in the best interests of the mother. For instance, why, when she was found in contempt and she didn't follow court orders, why now allowing the relocation would be in the children's best interest, why she would then follow those court orders. Why, under all of the specific factors, and I'll give examples, the mental and physical health of the individuals involved under factor A5. There was questioning by Dr. Weinstock whether mom is capable of understanding that as co-parents there should be equal discussion, and it's not appropriate for her to just make a decision because she wants that to be. Why did that factor weigh in the court's mind in favor of the relocation? In terms of the factor of the relocation being made in good faith, the court had evidence from Alyssa Liner on 2 different occasions that mother had already discussed moving to Sweden, and that mother thought that father was too lazy to do anything about it. That was not disputed by mother. Her testimony wasn't disputed. Why did the court then find that mother was making a relocation in good faith?
And your point, counsel, is that the Superior Court had to find it was in bad faith, given that?
No, Your Honor. My point is, why didn't the court, what was the reasoning that it was in the best interest of the children, given that undisputed testimony that it was not in good faith? Why is it in the best interest of the kids under that factor to allow the relocation, and in terms of every single other factor that weighed in father's favor as well? Thank you.
And Mr. Gardner, you have rebuttal time left just as to the cross appeal if you'd like.
Sure, thank you. And Your Honors, Attorney Douglas Gardner, once again for appellee Annika Jackson. The trial court found that father had many opportunities to travel to Sweden and had not exercised those at any point. Father at one point indicated that he did not like to travel to Sweden, and so the suggestion by mother that that the cost, this $16,000 a month waived of child support, is somehow to offset some supposed transportation that father may hypothetically take. Again, that's too far of a leap for the court to use in order to simply deviate child support to zero. The only finding that the court made that even comes close to as to why it deviated the child support to zero, and this would be on page 17 of the court's 21-page ruling, was the court stated that the significant costs associated with the travel expenses for the children in order for father to exercise parenting time. And so once again, it is not, as Ms. Ansel has suggested, that this was to pay for father's transportation costs. There is no other written finding, and I do appreciate Ms. Ansel's concession that this does need to be remanded back to the court for appropriate findings and for appropriate conclusions as to the enforcement of child support under the guidelines. The last big issue is the issue of attorney's fees that we've brought up. We do believe that this is an important issue for attorney's fees. The trial cost of this case and then the appeal cost of this case has completely drained mother financially. Father had testified that he would destroy her financially if he proceeded to go forward, and this case has done exactly that. We believe that that father's position in bringing this appeal on an abuse of discretion in light of the 21-page very detailed ruling shows that he has taken a very unreasonable position in this case. And so we are requesting that father be ordered to pay mother's costs and attorney's fees on this appeal. I've got nothing further, but I would answer any questions that the three of you may have.
No, thank you.
Thank you.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned.